हेलो एवरीवन, वेलकम अगेन। आज हम इंडियन पेनल कोड के दो इम्पोर्टेंट कंसेप्ट्स को जानेंगे, दैट इज़ गिविंग फॉल्स एविडेंस एंड फैब्रिकेटिंग फॉल्स एविडेंस। सेक्शन 191 ऑफ इंडियन पेनल कोड defines what is giving false evidence. It says that whoever being legally bound by an oath or by an express provision of the law to state the truth or being bound by the law to make a declaration upon any subject makes any statement which is false and which he either knows or believes to be false or does not believe to be true is said to give false evidence. तो बेसिकली सेक्शन 191 क्या कहता है? ये कहता है कोई भी पर्सन जो लीगली बाउंड है बाय एन ओथ या फिर बाउंड है किसी एक्सप्रेस प्रोविजन ऑफ लॉ के अकॉर्डिंग टू स्टेट द ट्रूथ, यानी वो बाउंड है टू स्टेट द ट्रूथ, बट बीइंग सो बाउंड ही मेक्स एनी स्टेटमेंट which he does not believe to be true or which he knows or believes to be false, then he is said to give the false evidence. For example, a person is asked that whether you know that B was at a particular place on such and such date. If A makes a statement that yes, I know that B was at such place on the particular date, but A was not sure or he does not believe that the statement given by him is true. So it doesn't matter whether the statement given by A is basically proved or not. What matters here is that A, while making the statement, was not aware of the truthness of that statement, or he believes or knows it to be false. So it doesn't matter whether the statement by a person is proved or not. What matters is that at the time of making the statement, he does not believe it to be true or knows it to be false or believes it to be false. So here we have the essentials. First is that a person must be legally bound by an oath or by an express provision of law to state the truth. So until and unless a person is legally bound to state the truth, he cannot be said to have given the false evidence. जब तक एक पर्सन लीगली बाउंड नहीं होगा तब तक जो भी वो स्टेटमेंट देगा, जो भी वो डिक्लेरेशन करेगा, इट इज़ merely an information given by him, not the evidence. So a person must be legally bound. Next, he makes a declaration upon any subject and he makes a false statement. Here, the statement is false means according to the person making the statement, it is not true and he believes or knows it to be false. So a statement is false. Whether in reality it is true or not, it doesn't matter. Next we have he must know or believe it to be false or not believe it to be true. So these are the essentials of section 191. I hope you all have understood this section very clearly. Next we have section 192, that is fabricating false evidence. Whoever causes any circumstance to exist or makes any false entry in any book or record or electronic record or makes any document or electronic record containing a false statement intending that such circumstance, false entry or false statement may appear in evidence in a judicial proceeding or in a proceeding taken by law before a public servant as such or before an arbitrator, and that circumstance, false entry or false statement so appearing in evidence may cause any person who in such proceeding is to form an opinion upon the evidence to entertain an erroneous opinion touching any point material to the result of such proceeding. A puts jewels into a box belonging to Z with the intention that they may be found in that box and that this circumstance may cause Z to be convicted of the theft. A has fabricated false evidence. So here A is causing any circumstance to exist. Okay, by putting the jewels into a box, he intends that such circumstance which he created is used in evidence in a judicial proceeding. Okay, and the evidence so fabricated makes the person who is to form an opinion regarding such evidence, to make an opinion that is erroneous opinion, because if such circumstance would not have existed, then his opinion might have changed. So by the existence of this circumstance, he is making an erroneous opinion. So this is the essential condition that the person causing any circumstance to exist does so with an intention that it is used in evidence in a judicial proceeding, and such fabrication has caused the person who is bound to form an opinion upon the evidence to form an opinion that is erroneous, which he would not have formed in a usual circumstance if this fabricated circumstance had not existed. So this is the basic concept which we must understand under section 192. First of all, a person causes any circumstance to exist, or makes any false entry, or makes any document or electronic record containing a false statement. Second, he must have the intention of using that fabricated material in an evidence in a judicial proceeding. And the person who is bound to form an opinion upon the evidence makes an erroneous opinion because of such fabrication. Then only the person is said to have fabricated a false evidence. Next, we have the punishments of fabricating and giving false evidence. First of all, we must know the series of reading these sections. First of all, we have to understand section 193, then 195, and then lastly section number 194. So, what section 193 says? It provides for the punishment for giving false evidence or fabricating the false evidence. Under this section, a person is punishable with imprisonment, which may extend up to 7 years, and he is also liable for the fine. Here, this section states that whoever intentionally gives false evidence or fabricates false evidence, he shall be punished with imprisonment which may extend to 7 years and shall also be liable to the fine. Next, we read section 195. It states that if a person gives or fabricates false evidence with intent to procure conviction of an offence punishable with imprisonment for life or other imprisonment, he shall be punished with the same amount of punishment as is given to the person against whom he gave the false evidence or fabricated the false evidence. For example, a person gives false evidence against B with intent to convict him of an offence punishable with imprisonment for 10 years. Then A will be punished with the imprisonment for 10 years. So here the person is punishable with the same punishment as a person convicted of an offence against whom he gave the false evidence or fabricated the false evidence. Next, we have section 194. Here, the question arises that whether a person can be convicted of capital sentence. So, for this, we have section number 194, which states that if a person gives or fabricates false evidence with intent to procure conviction of capital sentence, then he shall be punished with imprisonment for life or rigorous imprisonment which may extend to 10 years. But if, on the basis of his false evidence or fabricating false evidence, an innocent person is convicted of death sentence and the same has been executed, then the person who gave the false evidence or fabricated the false evidence shall be punished with death. So, here section 194 clearly states that a person can be convicted of the death sentence if he gave the false evidence or fabricated the false evidence on the basis of which an innocent person is convicted of the death sentence and the same has been executed against him. So, I hope all we have clear regarding section 191, 192 and 193, 4 and 5. So that's all for today. Stay tuned with No Legal World.